Part of the reason that councils break the law so much when it comes to homelessness law is that there's very little chance they're ever going to get held to account, and that's partly because it's very difficult to get a solicitor. Let's face it, even if you can get legal aid, there's often very little capacity that solicitors actually have to take on your case. And secondly, you can get it to the local government and social care ombudsman, but to do that you've got to bash through the whole council complaint process and all the delays and the resistance you get from that. And then you get to the local government ombudsman and then find out that they can only look at certain aspects of your complaint. So might seem really kind of hopeless in terms of, how do you actually get councils to follow the law? The answer is Data Protection Act, which might seem surprising. I know a lot of people roll their eyes when you hear about data protection, but the reality is that's because they don't understand it. Data protection law is absolutely beautiful. It's my favourite bit of law. There's so much power within it, and there's so much protection that people have against dodgy organisations, particularly powerful ones like councils, where it's doubly important that they follow the law because they're part of the government, and it's really important for democracy that all works. So in this video I'm going to explain a little bit about what's at stake, how you can use subject access requests to get compensation, to get housed and all that sort of stuff. I'll talk a bit about the law, and I'll talk about the practicalities of kind of working through the resistance you will actually get from councils often. And it seems to be increasingly a problem, so councils seem to be dealing with these kind of issues more and more by simply just not responding and kind of just ignoring the emails and whatever. So I'll give you a few examples from cases I've worked on just to start off with, just to give you an idea of what these records can look like, what you need to look out for, and kind of pick apart how these kind of records they can then be used to get someone housed and get them compensation. So this first excerpt is from an old case I worked on. The council doesn't actually exist anymore, so I'm not even going to bother naming it. But it was for a lady who was pregnant and she'd fled domestic abuse from Bedford and gone to a different council. And basically been gatekept. What the council actually did was they got a local charity to give her a bus ticket back to Bedford. So this is one of the kind of first complaints I worked on back in the day. And this was an excerpt from her record. So we made a subject access request. They provided the records in a paper form, which was fine. Scanned it all in and kind of picked it apart then. And there's probably about 80 or 100 pages worth of data in that record, because there's lots of kind of repetition. There's lots of kind of emails banded around and all that sort of stuff. This is basically the bit that won the argument and got the compensation. So bearing in mind she's pregnant, she's approached a different council. If you've watched this channel for any length of time, you can approach any council in the country and they all have a duty to accept the application. It's not for the applicant to prove their case, it's for the council to make the inquiries as are necessary. And in this case there would have been an immediate duty to provide safe interim accommodation to any council she went to, because she's pregnant, so she's in priority need and she's fleeing domestic abuse. So basically local connection doesn't really kick in at all. So she goes to the council, and this is the record that the second officer made. So obviously she'd had contact with them already, but the officer in this case basically said customer came in to supply proof of her pregnancy as previously asked. So immediately there's evidence of gatekeeping, because it's not for the applicant to prove their case. If you go to a council and say I'm pregnant, it's their job to make an inquiry of the midwife to establish whether or not you are actually pregnant, and whilst that's all happening you are in interim accommodation straight away. It's just not even debatable. That stuff should never happen as it happens here. So that's the first sentence. It's almost like the council was trying to see how many times it could break the law in one paragraph, and it did quite well, I have to say. So the second sentence, I could not understand why she was asked to provide this, as she does not have local connection. She's not working, she does not have any close relatives in the area. So again, this is the second bit of gatekeeping. Local connection is entirely irrelevant in this stage of the process. As I say, in this case of domestic abuse where she's fleeing an area, they wouldn't be able to refer her back to Bedford anyway, but that's essentially what they did. So they kind of said, why are we even looking at this application? She doesn't have local connection. So immediately this is our second point of gatekeeping. Third sentence, I've looked at her initial assessment and advised her that she would need to make a homeless application in Bedford, which again is completely untrue. If you're fleeing domestic abuse, more than ever you can approach any council in the country. You can approach any council in the country anyway. In most cases it's not worth it, because they're just going to refer you back to your home area if it's safe to do so. There's a whole bunch of kind of caveats with that, so local connection cannot be used to deny people help. But that's what they kind of did in this case. So that's the third issue. And then just the kind of record includes the fact that she advised me she was scared of her husband and it was not safe for her to return. So in the council's own record here, we've got evidence that she told them, the client told them about the fact that she was at risk in Bedford, and that they've kind of just gatekept it blatantly. And so this was essentially all I needed to get that complaint run through. So I sent the first stage complaint off. As you can imagine, first stage complaints are never upheld, so I had to go to stage 2. And the stage 2 complaint was actually really stupid. It just kind of suggested to me that this council wasn't used to being challenged at all, because what they did was they said, yeah, fair enough, we made a mistake, we'll pay £150 compensation. And I was like, that's nowhere near enough on the guidance and remedies. So I just had to take it to the LGO. If they'd have actually given a suitable amount of money at the stage 2, it would have never gone to the LGO, but it goes to the LGO, they investigate, they uphold it, they give her a lot more compensation than that. And also they basically tell the council, the housing officers have to do training, because this is evidence of the fact they just really didn't know what they were doing. So this is just one example. I'll give you a couple more because it's worth just kind of seeing how these kind of cases are made. So this one here is from an extract, again, different council. I won't name which one it was. Again, it was actually a lady who was subject to domestic abuse, and she'd been on the council's website and filled in the online form as advised to on the council's website. So often councils just point you towards the Part 6 application form. But this is the important thing. On the application form for Part 6, she ticked several, 3 boxes that would all potentially mean she was homeless or might be homeless. So she ticked the overcrowding box, she ticked effectively the unaffordability box, so she ticked the fleeing, violence, harassment and or abuse box. And immediately that gives the council reason to believe that she might have been homeless. So she's already asked the council for help with housing. Now in the actual form, she's telling the council that she might be homeless through the risk of abuse. If you look at 18.6 of the Code of Guidance, it makes this point explicitly. The council should basically be very careful to make sure that when people are applying under Part 6, that they are, if they're giving reason to believe they might be homeless, that it's treated as a homeless application. So this, again, this family should have been housed immediately in safe accommodation. Instead, this just rumbled on for years. Lots of dicking about with the council in terms of providing evidence, all that sort of stuff. It was ridiculous. But again, this simple record here gave us a date, because this was also dated. It gave us a date that this had happened. That meant that when we went to the LGO, it was just really straightforward. On this date, this lady told the council that she was at risk of abuse. They did not engage with Part 7 of the Housing Act. There, it's just gatekeeping. It's just straightforward. And so when you calculate the compensation, you go, how many months has it been since that happened to the point where she was housed? Fortunately, in this case, she was eventually housed. And so that it just makes it very easy. And it's this sort of detail that you need to kind of pick apart the subject access request. As I say, you kind of get hundreds of pages of data sometimes, and you just need to spend the hours to go through it and work out, okay, where can you show the council went wrong? And this is another good example. I'll give you one more example as well, which is again it's also almost funny. But basically, this was a guy who had long-term mental health issues. The council had already accepted he was in priority need and he was owed the maid housing duty, but they left him in this temporary accommodation block in Bedford known as the Golden Bull Apartments. Well, it was called the Golden Bull Apartments. It wasn't known as. It was the Golden Bull Apartments, and it was just an absolute zoo. Kind of all sorts of antisocial behaviour going on. Just horrendous. No good for people with mental health issues. No good for people who haven't got mental health issues either. And you can see from this record, so this is the Housing Options team leader instructing her frontline worker to basically kind of prepare the way to try and get rid of this guy. So, hi, whatever this housing officer was called, I see Mike Hyden's involved with this one. We need to do full medical inquiries on this as we previously accepted him as priority need and accepted full rehousing duty. And then it says so this is where it's kind of setting them up to try and get rid of him. He chose to leave TA and we ended the duty. I've asked rehousing to make sure there is actually a letter on there, so this is obviously a new application. Now that's not true. If I go to another email she sent, again it's addressed to the same housing officer. This applicant is showing his main duty discharged after leaving Golden Bull Apartments last year, but there is no discharge letter on file. Just us are involved. That was the charity I work for. So can we get one put on there for the record? And this is more than a year later. That says to me, the way I would read that is potentially that's an instruction to a frontline staff member to write a letter and then presumably backdate it for a year to kind of show that the duty was already discharged. And what then happened was, you can kind of see it in the records, is she then kind of emailed the rehousing team leader who said there's not, this duty wasn't discharged, what are you talking about? And so effectively we didn't even have to make a fresh application. It was just a continuation of the fact that he was already owed the main duty. But again, you can kind of see from the detail of the emails that you see flying around and kind of the back office stuff, you can get the evidence you need to actually show that the council does still owe a duty to someone. And in this case, in this case it was pretty straightforward. He got housed not long after this in social housing, but you can kind of see how you can piece together these emails and these kind of little snippets from the records to make your case when you complain. And that's why complaints don't need to be very long. Going back to the kind of previous examples, really your complaint only needs to be one paragraph. Here's the evidence of the failure, this is what it's led to in terms of that person being at risk of homelessness or actually homeless and at risk of other abuse or whatever. that is enough to get a complaint upheld. Bearing in mind the first stage will never be upheld in my experience. There's one time it was upheld by Northampton Borough Council in my experience, and that appears to be actually an admin error, but anyway, that's another story. So that's the kind of thing that's basically available for you if you make these subject access requests. So I'll explain a little bit about the law and how you can make them as best as possible. And then I'll kind of give you another example of like the kind of resistance you get and what you can do about that. So legally speaking, you can, any organisation that holds data about you, you've got a right to access it. There's a couple of exceptions. So let's say you've just committed a crime, you can't do a subject access request to the police to find out exactly what their investigation is, so you can kind of get an alibi or something. Or if you kind of committing fraud or something like that. So there's certain things you can't get. Almost all cases you're going to be involved in, you will have a right of access to that data, and it's all the data, and it's free to do. It's an onerous duty on councils. Again, it's one of those ones which is supposed to be. That's the way it's meant to be. It's about protecting the individual from basically organisational abuse, effectively, and kind of and misuse of power. So there's two ways I'd recommend making a subject access request. Firstly, as with homeless applications, ignore the online form, because the problem with online forms is you don't necessarily get any kind of proof that you've actually sent it. So if you chase them up 2 months later and say, I made an application subject access request a few months ago, they might say, well, we haven't got it on the system, so you didn't. So you want to do it in an email. That's the first option, and the email address you send it to will actually be on the council's privacy notice. So if you just Google, Bedford Borough Council privacy notice or something like that, you'll probably get a number of documents, because there'll be different privacy notices for different areas in the council. But on the privacy notice, it has to give the contact details for the data protection officer, which is like the kind of the person who's overseeing data protection stuff in the council, or any organisation for that matter, or any big organisation, I should say. And often the email address will literally just be dpo@bedford.gov.uk or whatever, so it's not often very difficult to find out. So you send an email to the data protection officer. You say, "Dear Data Protection Officer, I wish to request a copy of all my records held by the council," and then you want to do a couple of things. So you want to probably specify the dates that you want it for, because obviously, if I made a subject access request to Bedford Borough Council right now, I'd get my council tax records going back years, and I don't care about them, so that's not relevant. So you might want to specify, a date period. Say, if I made a homeless application in February this year, I'd probably actually want to make the subject access request to go back to January, just to make sure I capture everything. And I would say more than that, you don't want to be much more specific, because the problem is if you say I want, all the stuff from housing, you might not realise it, but you might have actually been kind of assessed or kind of dealt with under different departments like social care or safeguarding or something like that. And actually you want all of it. So I would just say, literally be quite generic. I wish to request all my records from the council going back to January 2024 to present. Thanks very much. And that's essentially all you need to do. Send it off. They've then got a calendar month to basically respond to that. There are some exceptional cases, and I've only seen this once, where they have an extension. They can get an extension for 2 months on that. But in the case I had experience of that with, it was literally because the legal team had to redact a whole bunch of stuff, and they had to kind of go through it with a fine-tooth comb. It's a sprawling case. It got really messy. But in most cases, you're going to get that back within a month. However, you won't get it back within a month, which is what I'm going to talk about at the end of the video. Or you won't get all the stuff often. So that's option one. You send an email to the DPO. The second option, and I haven't used this yet, so I'm kind of speculating, but I think it should be a really good way of doing it. If you go on the ICO's website, the Information Commissioner's Office, which is like CQC or like Local Government Ombudsman, but for data protection issues, they have a service where if you fill in the right details, and again, you're going to need the DPO's email address anyway, so you basically fill in the boxes, pretty straightforward stuff, you put in the Data Protection Officer's email address, and then what I think happens is the ICO then send an email to the council and say, Mike Hyden has made a subject access request, this is what he wants, over to you. And I would speculate that because it's the ICO, it's coming from the ICO, councils are probably much more likely to actually kind of be motivated to sort it out properly, because you effectively already brought the ICO's involvement into it, even though it's only automated. I think it would probably just have that effect of actually kind of giving a kick up the bum to the council to get it all sorted. So there's the two ways. But the resistance you're going to get is, it's kind of predictable. So I'll give you another example of a council I worked with where, again, it was actually another victim of domestic abuse, actually, who fled to the area from Bedford and been gatekept, predictably. And we'd basically waited until she was assured a kind of a social housing property. Sometimes you've got to complain earlier than that, and I've done a video about that, but in most cases I'll try and wait as long as possible. And when I say wait as long as possible, you need to do it within 12 months really. You need to get to the LJO within 12 months, so you need to kind of factor in how many stages of the complaint process there is at the council. So, you know, in this case, it's pretty typical. It's about 6 months or 7 months after the actual failure happened. But as I say, by this point she's got an assurance of actually getting housed properly, although she's still in TA at this point. So she makes a subject access request, you know, kind of following the usual sort of stuff, emails the DPO, and then we hear nothing. So we wait a couple of days until after the time limit, just to, you know, give them a bit of chance, and then we hear nothing at all. She sends some emails to them chasing it up again, and I then get, you know, basically I then make a complaint, which is, you know, the way I do things. I've made a complaint to the chief exec and the counsellor who is kind of overseeing data protection stuff, which there will be one. It won't be called a data protection counsellor, but if you look into the kind of the inner workings of the council, you'll see that there's a counsellor who covers like information governance or something, and that will kind of cover data protection stuff. So I made a complaint and got a response back from the data protection team in the first instance, and you know, here's the email. The guy wasn't called Pete. It was called something else, but I've just anonymised it. So, good morning, Mike. We did provide records within the timescale. We contacted her to say that the records were available in a password protected area. Link was provided, and that she could receive the password by phoning us up on the number provided. Blah blah blah. You can read the rest of it. So, yeah, as per council's response, first response is to say it's the person's fault. You know, it's not our fault. It's the person's fault. So I was like, okay. Went back to the client and said, you know, they're saying you didn't email them. She said, yeah, here's the emails. I've got them here. I looked at them, did a bit of detective work, and I realised that what had happened is the council had told her the wrong email address. So if you actually kind of look carefully, the email address they advised her to contact was dpo@northants.gov.uk rather than northants.gov.uk. So effectively her emails went off and they didn't bounce back. So she assumed she'd done it all, you know, correctly. And, you know, kind of her further emails obviously went into the ether as well. So I went back to this guy and said, you know, you made a bit of a typo here, and, you know, therefore you haven't actually complied with the Data Protection Act. And so, and respect to Pete, he actually apologised for this in the end. I said, fair enough, yeah, my bad sort of thing. So that kind of then got the council moving. They then provided a bunch of data. But then you kind of, again, you know, I've already had to make a complaint to the chief exec to get this far. You then have a situation where when you go through the records, you can see a whole bunch of stuff is missing. You're like, well, hang on a minute. There's no personalised housing plan in this stuff. There's nothing about an assessment about the person's disabilities. Essentially, there's a whole bunch of stuff missing, and it just so happens that the stuff that's missing is the stuff that I need to get a compensation for this situation. So, you know, I then kind of made another complaint, and just kind of, this is, again, I'm not going to read it word for word, but you kind of a list of things which I can see are missing, and there's probably more stuff that I'm just not aware of, but the things that I knew were there was going to be things like the email chain between the different housing officers that I knew had happened because I'd seen kind of, I was copied into some of it and so on. So I knew that there was a bunch of emails that hadn't been provided at all. Again, you know, kind of in terms of the council's correspondence with Midland Heart, which kind of provided some of their temporary accommodation, and, you know, got a bit messy. And then kind of, yeah, again, another bit, you know, kind of relating to the advice that she was actually given in the first instance. And again, it turned out that didn't exist either. So, you know, in one sense, some of this stuff I'm kind of requesting for and making sure doesn't exist is because it actually doesn't exist. And that's part of the complaint is they didn't do a PHP, they didn't do an assessment, all that sort of stuff. So that's kind of what I was really kind of wanting to home in here. So, but I'm having to make another complaint to actually get it. And again, at this point, this guy Pete actually was really helpful from that point. He kind of said, you know, I've looked through it all, can't find this other stuff, but here's some more stuff. So I did get some more stuff. And then he kind of signed off just by saying, yeah, sorry for the cock up and the typo earlier in the process. Now, I've got no problem with people making mistakes like that and kind of owning up to it. It's, you know, that's just life, isn't it? That's the way it is. But what then happened was the first stage complaint was then responded to by some senior person in the council who then basically said, you know, what you're talking about, we did provide the information. And it was like, you obviously didn't. I've already kind of made this clear. So if you, I can't imagine many council workers are watching this video, but if you're a council worker and your default position is just to deny everything, all it does is it just pisses people off and kind of makes people go at you even further. So in this case, I kind of ploughed through that stuff, ended up getting a compensation, and she was housed, so it's kind of, you know, good outcome in that sense. But that is kind of what it takes to get a subject access request, but it was worth the effort because when you finally get those records, again, you just kind of go through it, what's missing, what hasn't been done, what's been done wrong, all that kind of stuff. That then becomes the framework for your complaint to then get sent off and get compensation.